Hi, I'm going to go ahead and get started. My name is Katina Combs. I am the Interim Director with the St. Louis Metropolitan Equal Housing and Opportunity Council, and you're now attending the Fair Housing Rights session here. I am going to go ahead and get started. I see that there are 31 participants here, and if you have any questions, you can definitely type in your questions at the Q&A, and we can answer those for you. And if you have any problems with hearing the volume, if you could just send a little note and I will be notified that you're unable to hear me. But I'm going to go ahead and proceed with the slideshow today. And thank you so much for attending. I appreciate your time here today and enjoy the session. So we're going to talk a little bit about EHOC and what we do. EHOC was founded in 1992. So we are the only fair housing organization of its kind in the state of Missouri and serving the St. Louis metropolitan area, and southern half of Illinois is our service area, but we do lots of work outside of our service area because we're uniquely situated in doing this sort of work. So we are a nonprofit fair housing organization assisting people who believe they have been discriminated against in the housing market. EHOC mission is to work to ensure equal access to housing for all people through education, counseling, investigation, and also enforcement. So there's various components of the organization that we are conduct, such as education. We have a robust education and outreach campaign. We also provide counseling for those who are experiencing tenant-landlord issues, facing eviction issues, or may have issues with their landlord as it relates to repairs for their units or for their homes. We also conduct investigation and enforcement, and that's really my area of expertise here at EHOC. My area of expertise is the testing investigation, systemic investigation, and enforcement of the Fair Housing Act. I've been doing this sort of work for about 23 years, so this is where my area of expertise lies, right here, in investigation and enforcement of the Fair Housing Act. The Fair Housing Act of 1968 prohibits discrimination against protected class during the housing-related activities, and it was the last legacy of Dr. Martin Luther King. There are 7 protected class under the Federal Fair Housing Act, and those protected class in which one can file a complaint is race, color, national origin, religion, gender, disability, and also familial status. Now, oftentimes we do get some clients that file a complaint under one or more of these protected class, and you definitely have the right to do so. For an example, we may see a complaint based upon race and also familial status. And familial status is what it is families with children under 18 years old. We oftentimes see a lot of discrimination in the area of familial status, on which some housing providers do not want to rent to families with children, especially if there's a second floor unit that is on the market for rent, or either if it's a 1-bedroom unit. Some housing providers believe that children should have their own bedroom at a certain age. And so that is also considered familial status discrimination as well. You may have some housing providers in which they segregate their apartment complexes and say, okay, families with children can live in specific buildings versus those who do not have children, because they want to keep the areas or those particular buildings quiet for working people. So we see that sort of discrimination and familial status discrimination. And then there's disability discrimination as well, which is something we see a lot here at the organization as it relates to reasonable accommodation. So you may have someone with a disability who needs to have a service animal or the emotional support animal to assist them with their disability, or they may need some sort of modification done within their unit that's very reasonable. And so at times we will see our clients request such things but are denied, and that is a form of disability discrimination under the Fair Housing Act. So we have housing and housing-related protected class. These are the protected classes under the Fair Housing Act in terms of which we focus on here at the agency is renting, the rental market, buying or selling a home, obtaining or refinancing mortgages, obtaining homeowners insurance, obtaining an occupancy permit, or dealing with zoning or occupancy issues, and viewing real estate advertisements. These are some of the areas that I focus on specifically when I am conducting my testing and investigation. Housing services protection under the Fair Housing Act. The Fair Housing Law applies to any person or entity whose actions can make housing unavailable. So an example of those are temporary or long-term shelters, organizations offering rental assistance like vouchers or subsidy, and we're talking like the Housing Authority for an example, agencies operating housing counseling and placement programs, clean and sober housing, transitional housing, motels that function as primary housing rather than vacation lodging. We also have some additional protected class under the Fair Housing Act. In the state of Missouri, for an example, ancestry discrimination is a protected class under the state Fair Housing Protection, but not as a federal protection. We also have the St. Louis County Municipal Protections, which is sexual orientation and gender identity. And again, that's just specific to St. Louis County municipalities. For St. Louis City only, we have an extension of protections such as gender identity and expression, sexual orientation, and also source of income, which includes Section H vouchers or housing choice vouchers. University City, Olivet, Clayton, Richmond Heights, Kirkwood, Ferguson, Creve Coeur, Maplewood, and also unincorporated St. Louis County also have these protected classes. We also, again, service the southern half of Illinois, and some of their protected classes include the following: ancestry, age 40 and over, domestic violence status, marital status, military status, unfavorable discharge, sexual orientation, and we have also order protection, and also income is also protected in the state. Now, these are just state specific or municipality specific, so they're not considered a protection class under the Federal Fair Housing Act. But the great thing is that some of these municipalities, and also, for an example, Illinois has expanded their protected classes under their state law, which is great. So prohibited acts under the Fair Housing Act is a denial of availability. An example of this would be someone who has inquired about a unit that is available for rent. Clearly it's available, but the housing provider has denied them the right to rent said apartment for a variety of reasons that will be considered discriminatory under the Fair Housing Act. Just to give you just a really quick example, when I'm conducting my test specifically, and I'm looking at denial of availability, it could be the scenario I use with families with children. Perhaps when I'm conducting a test, and I've seen this happen over my course here at EHOC, is that I will have a tester who has children, and I would pair them up with a tester who does not have children. And sometimes housing providers would tell my tester who has children that that unit is no longer available, but they will offer that unit to my tester who does not have children. In regards to race, that we see that a lot too with race, in which they will deny housing to a person of color, although it is being advertised for rent. And when I send out a comparable tester who is a non-person of color, they are told that the unit is available for rent. So that will be a denial of availability in that specific area. Different terms and conditions are prohibited acts as well. And basically what that looks like is, I like to use my scenario of families with children in this case, in which you may have a couple or a parent who is looking for a place for themselves and their child, and they may say to the parents that we only rent to families with children on the ground floor. I see that a lot. And so, however, but there are units available on the second and third floor in which families with children are prohibited from living. So that is an issue of terms and condition under the Fair Housing Act, in which they are just restricting families with children to the ground floor only. Maybe they're trying to control for noise. That would be one of the things that I often hear from housing provider, is for reasoning for having such practices in place, is that because kids run around, kids make noise, and we don't want them or children running over folks' head at the lower level. And so they will only say that we only rent to families with children on the first floor only, or in this specific building. Although there may be units available throughout the complex on the second and third level, or either in another building, they will prohibit families with children from living in those specific units. And that is considered difference in treatment based on terms and conditions. Restricting choices will also follow in their example as well. Then we have discriminatory advertisement, provisions of false information, blockbusting, and refusal to make reasonable accommodation or modifications for persons with disabilities. And just to kind of expand that out a little bit, blow that out, again, I mentioned and talked about reasonable accommodation as it relates to service animals. There's so many different types of reasonable accommodations that people would need. Some folks would need like a live-in aid to stay with them a few days a week, which is reasonable under the Fair Housing Act. But the most issues that we see will fall under the refusal of reasonable accommodation would be the service animals or emotional support animals in which the house provider will not allow for that service animal to reside at the property, or either they would charge the tenant who has a disability pet rent fees associated with having a service animal, emotional support animal, and that is a violation under the Fair Housing Act. So anytime you have a person with a disability who needs such accommodations in that area or any area that is reasonable, housing providers need to make sure that they make that accommodation available to that tenant. So we have discriminatory treatment and discriminatory impacts, such as steering, meaning you're steering individuals to one particular area of a neighborhood or outside of a neighborhood to try to keep it one particular way. And then we have screening, which is a really big issue in voice profiling, including redlining. The screening portion of this is when you have a third party that is screening on behalf of a housing provider. At the request also of a housing provider, they're just screening out certain individuals that they do not want to rent to at their subject property, which potentially could be discriminatory under the Fair Housing Act. Then we have voice profiling that happens quite a bit. I always say that everyone voice profiles. It depends on what you do with it after you've done that. Oftentimes when kids, for an example, are answering the phone, they will say, mom, or dad, there's a woman on the phone, or there's a man on the phone. So it really depends upon what you do with that information once with your assessment of that individual on the other end. In my testing career, EHOC, I've had a lot of voice profiling cases in which some housing providers will screen out to make sure or checking to see the race of this individual based upon their voice profile and location in which they say they are moving from. So voice profiling indeed is a real thing, and it happens quite often as well. The enforcement component under the Fair Housing Act consists of filing complaints with HUD, Missouri Commission on Human Rights. Now, I will say MCHR no longer accepts fair housing complaints since the law has changed. In the state of Missouri, they're no longer substantially equivalent to conduct investigation for fair housing related issues. They lost their standing as a result of the law that passed here in the state of Missouri. And then we have other local agencies or state agencies of enforcement. For an example, the city, St. Louis City, has an enforcement component within their jurisdiction for the city. Other components of enforcement would be conciliation, in which I have been involved in quite often here at the agency. Private lawsuits, and also retaliation is protected as well. So we're going to talk a little bit about gender discrimination. Sexual harassment is something that happens quite often. We here at the agency have assisted several women who were victims of sexual harassment while renting that yield good results with the Department of Justice. Those cases were filed with HUD and subsequently filed with the Department of Justice for further investigation and conciliation. And what we see with this, with sexual harassment specifically, this is really an issue for single mothers, in which we see some housing provider engaging in this practice for single women with children, knowing that they're having difficulties making their rent. They may make suggestions of a quid pro quo type of scenario in which they will request some sort of sexual favor in exchange for rent. And so we do see this quite often. It's a big issue and a tall order to tackle across the country as it relates to sexual harassment in housing. Domestic violence falls under the VAWA. We see this as well, in which a person, be it male or female, is victim of domestic violence. And what happens is the client is the victim itself, also the client, is subjected to a termination of their lease, and they will have to move as a result of that domestic violence, or they will be charged for damages assessed to the subject property as a victim. And so I have had clients who were victim of domestic violence, and they were giving a emergency eviction as a result of that. And of course, it's not their fault, it's the perpetrator's fault. But what we do is we move in and try to stop that eviction from occurring, because it falls under VAWA and is a form of gender discrimination. So this is something that we're continually to watch at the agency, domestic violence as well as sexual harassment under the Fair Housing Act and gender discrimination. We have sexual orientation and gender identity. This is a growing area here, and where we're seeing many people come forward and say that they're being discriminated against because of their sexual orientation, also their gender identity, which is also an increased problematic issue that we're trying to get a handle on here. But this happens quite often too. And as a result of any form of discrimination, it causes so much of a ripple effect and creates a space for homelessness. And so we are dedicated to making sure that we enforce the Fair Housing Act to deal with these various forms of discrimination. For familial status discrimination, I talked about that, but we're going to elaborate a little bit more. It is illegal to discriminate against families with children under 18 years old. And again, I see that a lot. Pregnant mothers are also protected. Families attempting to gain custody of a child under 18 years old is protected. And then we have examples of prohibited actions, relationship to occupancy limits. And this is when you will have a housing provider say, we need a person, a mom or dad who has a child would need to have their separate bedrooms, which is very problematic, especially when it comes to affordability of housing. That's a big issue. And then we also have discriminatory terms and conditions under the Fair Housing Act as well. And then we have affirmative marketing permitted also. And bear with me, I'm trying to get my screen to move here. 1 second, I think it's a little stuck here. And then we're going to move on to disability discrimination and talk a little bit more detail about that as well. Any mental or physical impairment that substantially limits one or more major life activities is considered disability discrimination. For an example, sorry about that. For an example, we have blindness, hearing impairment, mobility impairment, HIV and AIDS, cognitive and learning disabilities, recovery from drug or alcohol addiction, chronic fatigue, and mental illness are examples of a disability discrimination or a disability under the Fair Housing Act. Protected is persons with a record of an impairment or regarding as such having impairment. What's not protected, though, is active drug users, those convicted of illegal manufacturing or distribution of a controlled substance is not protected. Then we have our reasonable accommodations again, which is changes in terms and conditions of a lease. Examples include handicap parking spaces, leasing, reading accommodations, and modified payments for SSI. And I'll just kind of explain a little bit more about the examples. Sometimes we have clients, because of their disability, may need a parking space that's a little bit closer to their unit. And so that will be a form of a reasonable accommodation, is asking a housing provider to provide a set aside space for a particular client because of their mobility impairment. And then we have a lease reading accommodation. Some folks who have disability needs to have a lease expanded in a very large print so that they can read that lease agreement. Many of the leases that I have seen are very, very small print, very fine print. And so a person who may have issues with their vision may need a reasonable accommodation and having the lease to be kind of expanded and in larger print so they're able to read it. For modified payments for SSI, for an example, in this case, you may have a housing provider within their lease conditions, terms and conditions may state that the rent is due on the 1st. There may not be, in many cases, a grace period, but a tenant may receive SSI or some form of subsidy or disability that may be deposited into their account on the 3rd or the 4th of the month. And so in this case, an individual may request a reasonable accommodation to pay their rent on the 3rd or the 4th or 5th when they are able to get their income to do such. All of these are reasonable accommodations in which a housing provider can make, and it's necessary that housing providers accommodate those individuals. We have the necessary plus reasonable equal must grant accommodation. And again, all of these very simple accommodations are reasonable under the Fair Housing Act, but we do unfortunately have some housing providers who are resistant to even the most reasonable accommodations for persons with disabilities. What are reasonable accommodations or modifications, I should say? There's a difference between the two. So the modifications consist of changes in a physical construction of a property. And this is, for an example, if a person with a disability who uses a wheelchair, for an example, may need a ramp installed to enter their unit, or they need a ramp installed to enter onto their patio area. They may need grab bars installed in their bathroom so they can easily be able to utilize the different facilities within the bathroom. And so they may also need to have some sort of modification made with their washer and dryer. Some units have like stackable washer and dryers, and for a person with a disability who are unable to reach high, may need to have their washer and dryer side by side versus stackable so that they can use it at their leisure. So that will be something that will fall under this category. At the tenant's expense, there are some modifications that the tenant will have to go ahead and assume in some modifications at their expense, unless it's a public housing or project-based Section 8. If it's a project-based Section 8 or public housing, well, then those entities will have to pay for those modifications. But if someone is renting from a renter or a house provider that provides market rate rent, they would then have to pay for some of those modifications that are costly. And then when they move out, they would have to make sure that it's restored back to its natural standard. Landlord must permit reasonable modifications so long as they are completed in a workmanlike fashion. Landlords may require to set aside for return to original conditions where reasonable, and sometimes housing providers don't require or request that. They'll just allow the modification to stay as it is. So again, some examples of modifications that could be made within a unit or outside of a unit that will make it easier for a person with disability to have full access to a unit would be ramps, grab bars, remodeling a kitchen to make it accessible, widening doorways, or to allow for wheelchair access. And I have been involved in many of these sort of design and construction cases where I am able to determine whether or not a facility or apartment complex that was built after March 13, 1991 has to comply with the Federal Fair Housing Act. So oftentimes I would do testing in this particular area for accessibility requirements. So there's a tenant responsibility here is to show that they have a disability and that the request is related to the disability. Landlords is not allowed to require independent medical exams, and landlords may deny requests if it creates an unreasonable financial or administrative burden, or if it endangers the safety of the building. So there are some requests that some tenants make that are very unreasonable, and the landlord does not have to adhere to those requests. In terms of medical examinations, landlord are not and cannot require a tenant to disclose their disabilities. I have seen that before, in which housing providers will ask a tenant what is the nature of their disability, be it physical or mental, to determine whether or not they will rent to them. And that is illegal under the Fair Housing Act. And tenants do not have to disclose that information at all. Making a request. Requests may be oral or written. So a tenant who needs such requests for reasonable accommodations, modifications, can simply make a request via oral or rental. We also recommend, or we suggest to our clients that they make those requests in writing so that we can have a trackable way of showing and that those requests have indeed been made. So the reasonable accommodation process begins with once the tenant tells a housing provider that they are disabled and needs something changed in order to accommodate the disability, a written request may be preferred, but not required. And we instruct clients to put things in writing. We think that's very important so that they can have documentation that such request has been made, and that is very necessary, especially as if it results in a fair housing complaint being filed. We're able to show the investigator that indeed the request has been made, denied, or ignored. Cannot require particular forms. Housing providers cannot require particular forms. And a request can be made at any time. So there's not a time limit on when a client or a resident can request a modification can be done. They can just make it simply upon request. Sorry about that, my computer's stuck here. Give me just a second, sorry about that. If anyone has any questions while I work through these technical difficulties, let me know. I'm not sure if John has or see any questions that folks may have in the Q&A.
We haven't had anything popped up quite yet. If we do, we'll let you know.
Okay, and I am working through the PowerPoint issues here. One moment.
So Katina, we do have two questions. I don't know if you want to answer them while you're working on this. One person asked, are these federal requirements?
Could you elaborate a little bit more on term, because the Fair Housing Act are federal requirements, but if you have a specific question regarding a specific protected class as it relates to federal requirements? When speaking about the Fair Housing Act, those 7 protected classes in which I named, race, color, national origin, disability, gender, familiar status, disability, those are all federal requirements. If you need additional information about that, let me know. I can elaborate. If you have a specific question as it relates to those requirements, let me know.
We have one question here that you might be good for you. What is block busting?
Oh, that's a really good question. So we have 2 things here. We have redlining and let me explain both. I think that's important to understand the both of them. So for block busting specifically, this is happening quite a bit back in the early, I should say late 90s and 80s is when, for an example, when Black families will want to purchase home in specific neighborhoods and areas, in an all-white area, for an example, all-white community specifically, real estate agents would send letters out. They would send letters out to the white homeowners and say, you know, you should put your house up for sale. This is a great time to move. Your property value is going to go down. Colored people are moving in. Black folks are moving in. They'll say, the neighborhood is changing. This will be a great time for you to sell your home. We recommend that you sell as soon as possible because your home is going to depreciate in value. That is an example of block busting. For redlining, which is quite a little bit opposite of that, redlining would consist of literally redlining, like you're completely not allowing a person of color to move in a specific community or neighborhood. And so I've seen maps in which there were red lines drawn in specific communities in which they would not allow persons of color, Black folks to live in specific communities, or either they would suggest to white potential homeowners to move in certain neighborhoods because of the demographic makeup of the community, and their property value would decrease as a result of that. So that would be an example of redlining. And the other example of blockbusting is just sending those letters out to, specifically, because it happened quite a bit actually for white homeowners when Black folks were buying houses, I'm going to say 60s, 70s, 80s, where real estate agents would send these letters out and say, hey, sell your house, the property value is decreasing, neighborhood is changing, everything will be different, it's time to sell your home. So that would be an example of what blockbusting looks like. I haven't seen blockbusting in quite some time. I've seen redlining a lot. It's been a while since I've seen blockbusting, but redlining, yes, is still a real occurrence that occur.
We have another question that I'm going to let you answer. How does a landlord accommodate a disability without asking about the nature of the disability?
Oh, they just accommodate the disability because there's really not a need for a housing provider to know the nature of a disability. For an example, I mean, first it's intrusive to ask somebody what is the nature of your disability. It doesn't really have anything to do necessarily, the housing provider knowing the nature of one's disability doesn't have anything to do with the accommodation. So an example of that would be if a person needs to have a living aid, for an example, this is a good one. If a person needed to have a living aid stay with them, maybe 2 to 3 days a week, and they are, went to the housing provider and said, hey, Mr. Landlord, Mrs. Landlord, I need to have my aide live with me or spend the night 2 to 3 times a week because of my disability, that request for accommodation is reasonable. What the landlord or housing provider should not ask is, why do you need this person to stay with you? What is your disability that you need some help? That is a violation of the Fair Housing Act. So you could go ahead and exercise a reasonable accommodation or modification for that example, for that matter, for a person who has a disability without asking them the nature of their disability. I hope that answers the question for you.
Katina, just to clarify, housing provider can't request any information about the disability, but they can request documentation from like a medical provider about the accommodation, correct?
Yeah, so a housing provider could say, okay, you need a reasonable accommodation. I just need to get a letter from your physician or your counselor stating that you need to have a service animal, or that you need to have an emotional support animal, or that you need to have a ramp installed. They don't, so the professional, the medical professional doesn't have to go into specific details regarding the nature of a person's disability, but the housing provider can say, all right, that's fine. I need to get a letter from your physician or from your counselor stating that you need such accommodation to be made, without it going into the specifics of what the nature of the disability is.
So another blockbusting, redlining question. It sounds like blockbusting is more grassroots and redlining is institutional.
That is correct. Yes, correct. So blockbusting is more of a grassroots effort, and redlining indeed is definitely more institutional. And it's a real unfortunate situation because either way, blockbusting or redlining, it really creates a problem with the diversity and the growth of a community, and it prohibits, whether you're Black, white, or whatever your national origin is or your race, it prohibits the growth and the development of a diverse, robust community. So they both have negative effects for the community at whole. Any additional questions? I think my PowerPoint is somehow stuck for some reason, but I'll be more than happy to answer any housing related questions or discriminatory questions based upon the prior slide, or if you want to know a little bit more about testing and how that works, I can speak to that as well. Testing is a great way to determine whether or not a housing provider is engaging in discriminatory practices. I've conducted well over 1,000+ tests here at the organization, which resulted in some really great cases in lending, of course, in the rental market and the homeowners insurance market as well. My testing that I conduct on behalf of the agency and the community at large has yielded some positive changes for the community and for residents within the within our service area. I think a question has popped up here.
Yeah,
Yes.
Katina, so that question is, how do you test? And we had had it in a previous session, a question about how does one become a tester?
Okay, yes. So how does one become a tester? You can just simply reach out to me. Although I'm the interim director, I still work in the enforcement area for the organization. So I still conduct testing, whether it be systemic testing, research-based testing. I still am that person to speak with about testing. I conduct and host a tester training that lasts about 2 hours via Zoom. So if you're interested, you can definitely reach out to me regarding testing. I think the other question was about testing itself.
Yes,
How
can
do
you
I
go into more details on how the testing works exactly?
Oh, absolutely. Yes. So this is my fun area right here. So I test various areas of the housing market. I test for race discrimination, familial status, disability, national origin, gender discrimination, all of those 7 protected classes. So what I would do, I think the most easiest ways to explain mystery shopping. Mystery shopping is a great way to explain testing. So what I would do typically if I'm testing for race specifically, I will conduct some research and determine which housing provider that I will want to test. And it's not because they're necessarily engaging in discriminatory transactions or behavior. I do a lot of audit-based testing here at the organization and complaint-based testing. And so basically what I would do in the context of an example of a race test is that I will create profiles for both my Black and white tester. They're very similarly situated in terms of income, education, family composition. So the only difference between the two is the race, that person's race. And what I am looking for when I am testing for race to see if there is a difference in treatment. Various things happen with my race cases that when I'm doing testing. Sometimes a house provider will ask leading questions to the tester, my Black tester specifically, because they're voice profiling as well. Okay, although they kind of go hand in hand. They would ask my Black tester, so where are you moving from? Okay. And so in some of my profiles that I profile is like a script. Okay. It's a script for my testers. Okay. And so I would have my tester to let the house provider know that they are moving from North City, for an example, North St. Louis City, Natural Bridge, and in Union. And they want to move over to, for example, the St. Louis Hills area. And sometimes when the tester mentioned where they're moving from, I've seen in my test cases in which housing providers will inform my Black tester that the unit has been rented, it's no longer available. But then my white tester would get a different response. My white tester is told the unit is available, how many units are available. And also a housing provider will then say to my white tester that they can come by and take a look at the unit that is available. And so that's how a test is structured. Testing is an amazing way to find out whether a housing provider is engaging in discriminatory practices. Also, it is a great way to find out whether or not a housing provider is doing the right thing. So I'm not always necessarily looking for differences in treatment. I am looking also at housing providers who are really doing good work. They are doing the right thing. They're treating everybody the same. There is no differences in treatment with this housing provider. So we applaud those individual housing providers that are making units available to everyone without discriminatory transactions in place.
Another question is, when should we reach out to EHOC versus a lawyer or something?
Well, the great thing about EHOC is that we have a legal team here. We have 2 attorneys. We're a nonprofit, so we don't charge a fee for service at all. Also, the great thing is that this is where we sit. We sit in the area of fair housing, so we're experts in a sense, is that we understand the Fair Housing Act inside and out. And so we know how to package up and bring a great case on behalf of individual or community that has been faced with discriminatory behavior or transactions. And so, EHOC is a great first step in reaching out. If you believe and feel or you know someone that has been a victim of housing discrimination, we are that agency that can assist in various ways with our robust legal team that we have here. We have 2 attorneys that are amazing, who do great work and who are great advocates for those who've been discriminated against.
This question didn't come up in the chat, but I have it. Is EHOC just limited to the areas of St. Louis and then Illinois, or do you help get testers throughout the state?
So I have worked with folks throughout the state who are interested in being testers. And the other side of that coin is that I have tested well outside of our service area, well outside the service area. So I've done a lot of testing in the Boot Hill areas of Missouri. I've taken a field trip, I call it a field trip, down to the Boot Hill area to assess, the different types of housing stock that is available, met with different people who may have had issues. And so we always extend ourselves outside of our service area. So if we get a call from someone in Poplar Bluff, or if we get a call from someone in Sykeston or Cape, we take those cases. We work with those individuals who are calling alleging discrimination or have a tenant landlord issue as well. Or if we have someone who's interested in conducting testing and they live in these certain areas, I do a lot of phone testing or also site visit testing. So we expand ourselves and we stretch ourselves wide. We cast a wide net in the state of Missouri. So we try not to exclude anybody. We really welcome any complaint, whether it be inside of our service area, outside. Myself personally with testing, I test on a national level with the National Fair Housing Alliance. I've done a lot of testing in various states. Many states, as a matter of fact. So we do a lot of work outside of our service area.
Do you have a referral process?
In terms of referrals for our complaints, we do. So for an example, well, in various ways. So let me start with the complaints process first. If someone contacts our office and say, hey, I have been a victim of discrimination, some complaints I can test, some I cannot test, but it will go through our legal department, and then those cases will be referred to HUD for investigation, for additional investigation. HUD is able to do investigative work that we don't have the capacity to do. They're able to do record requests, they're able to dig a little deeper in the investigation phase, but we're always there working with the client throughout the referral process when that case is referred to HUD, or if we're working with a case in Illinois, those cases are referred to Illinois Commission on Human Rights or the HUD office in Illinois. So that would be the referral process. Our sexual harassment cases are often referred to Department of Justice. We do have some local referrals that we do. There are some cases or issues with tenants that we do not deal with because we don't have the capacity to do so. And so we will refer them out to local agencies who are equipped to handle those particular issues. Do we have any other questions about testing or education or referral or reasonable accommodation or any aspect of the Fair Housing Act? Any questions about that? I didn't see any more in the chat here.
Oh, I think we just got a couple popped in.
Sure.
Any information specifically someone would need to bring with them when calling with a complaint?
Okay, hold on. Can you repeat that for me?
Yes. Is there any information specifically someone would need to bring with them when calling with a complaint?
Oh, yeah. So what we need basically is the housing provider information. We would need to know the nature of the complaint. A lot of times we get a lot of complaints regarding tenant landlord issues. Although, our mission is fair housing related. Well, tenant landlord issues are a fair housing issue. But if you just simply bring the issues in terms of what we will need is the housing provider information, address and such, the housing provider's name, and the issue that is in question is what we would need in order to proceed with any sort of action against the housing provider.
And Katina, can you tell us a little bit about, so if somebody calls and makes a complaint, what are the steps that they can expect that EHOC will take to follow up? And what kind of follow-up do you need from the person calling in to make a complaint?
So yes, when one calls our office, we have a robust intake department that's really detailed about gathering information from the resident, the client, or the complainant who's calling our office alleging discrimination or either a tenant landlord issue. And so what we do is we provide education off the top. We want to make sure that anyone that calls our office is educated about fair housing law. And we also provide information regarding tenant landlord issues. And for an example, if someone is calling regarding the landlord won't make repairs at their apartment, we gather that basic information from the client, their full name and address. We gather information regarding the housing provider. And what we would do is still send that information to our legal team, and they will assess the nature of the complaint. And then they will follow up with the intake department and making sure we get the necessary documents out to the complainant, the client, and also the respondent to try to bring about a resolution. So the great thing about EHOC is that when folks call our office, we don't just leave it there as a phone call. We walk everyone through from the beginning to the end, because our goal is to make sure is that there is a resolution for the client. We want to try to find a resolution for the client. So we will walk them through from the beginning of the process to the end, and making sure that they're getting the necessary help that they need, whether it be a tenant landlord issue, or if they file a complaint, a HUD complaint. We represent the complainant in most cases, unless the complainant says something differently, and we don't charge them a fee. So if a complainant, we always give the option of EHOC representing them in a fair housing related issue, and they can choose to do so. And if they should choose to assist or need our assistance with that complaint, we are there providing assistance, participating in the conciliation between the HUD investigator, the respondent, and the complainant. We are there until the very end of that complaint.
Katina, I don't know if you had a slide with your contact information, but are you able to provide that to people who want to get in touch?
I can put it in the chat for you. Would that suffice?
I think so. We'll just need to make sure. If you do, just make sure everyone can see it, not just hosted panels.
Yeah. So what I'll do is put my name here. I'm actually typing it out right now. And I put it to everyone. And then I will put my email address. I hit the back button too soon. You can tell I'm a typist. But I'll go ahead and start this again here. Okay, so I put my email address here, which is kcombs, KCOMBS at EHOC-STL.org. Again, that's in the chat, and I'll hit, there you go, for everybody to see. That is my first name and last name, Katina Combs. And my email address is kcombs at EHOC-STL.org. You can reach out to me if you have any further questions or anything that I didn't cover, or maybe something that you're unclear about. If you have someone that you want to refer, you can definitely send them my way, no problem. If you have questions about becoming a tester, you can definitely, I will definitely help you with that as well. We do provide a stipend for our testers, so we do pay our tester just a minimum stipend for conducting tests with us and helping us eradicate housing discrimination. Did everybody see my information, John? Are you able to see that?
Yes,
chat?
it should be available to everybody. If anybody can't see it, feel free to put a response in the Q&A. Okay, perfect. Thank you.
Okay. Perfect. And again, I do apologize for my slideshow. It just froze on me for some reason, and it's still frozen. But if any other questions I can answer for anybody? Any clarifications that I can make for anyone who was unclear about my response to their question? No? Okay.
We're not seeing anything come up.
Okay. Well, John, did your team have any questions for me?
I don't think so. I think we've been sending out the slideshow, the slide presentations afterwards, but I'm sure we'll work with Marissa on doing that. I think she's been doing that lately. So I think people will at least have access to the information, even though it froze up a little bit today.
Yeah, sorry about that again. I do apologize here. But if no one has any additional questions, please reach out to me if you do via email. I'll be more than happy to speak with you. If you want to send me a message via the email, and if you want to speak with me, no problem at all. I'll be more than happy to answer any questions for you that you may have in the area of fair housing and tenant landlord rights. We have a plethora of information in our office for individuals who may need some handouts or such. I'll be more than happy to send those to you via the email for you to print at your will. No problem. But if we don't have any additional questions, John, is it okay to wrap this up?
Yep, we can go ahead and end it. Just to remind people, I believe that these are being uploaded to YouTube if you do need to review the information again. And I believe that the presentation should be sent out as well. I'll double check with that and make sure, but I do believe that these are being uploaded to YouTube. If you do have any information or need extra information, Katina, you've been absolutely wonderful. Thank you so much. And feel free to contact her. She really knows what's going on in fair housing. So that's perfect. You guys have a good one.
Thank you so much. Have a great day.